and welcome to the Immigration Brief, where we break down the latest developments and practical insights in employment based immigration law. I'm Naveen, and I'm joined by my partner, David Fullmer. Every other week, we dive into issues that matter the most to employers, HR professionals, and immigration practitioners. Today's episode, we're going to focus on wage compliance, a topic that's foundational to both H-1B and PERM processes. Whether you're sponsoring a foreign national for a temporary work visa, or pursuing permanent residency through labor certification, understanding how wages are determined and documented is absolutely critical. So, to start, David, let's talk about the basics. What does the law say about required wages for H-1B workers?
The first concept to understand when looking at wages for H-1B workers, and it also applies to other types of work visas that are supported by LCAs like E3s and H-1Bs. That first concept is that the worker needs to be paid the required wage. The required wage is the higher of the actual wage that is paid to other workers at the employer who have similar jobs or who are working at the same location, who have similar qualifications. It's the higher of that actual wage and the prevailing wage, which is determined by wage determinations, and the prevailing wage also goes on the LCA. So let's take a deeper dive now into actual wage. Naveen, do you want to talk what actual wage is all about?
Yeah, so the actual wage is the wage that the employees at the same work site are who are similarly employed are paid. And when you're talking about similarly employed, it's really the experience, the qualifications that are required to perform these duties. And of course, if there are no similarly employed employees, then the employer, should look at other people in that area who are in a similar position, and they also need to account for adjustments such as cost of living increases, bonuses, and promotions. And so this is key to determining, what the actual wage is, and then also, to document that when you're preparing a labor condition application and your public access file.
Naveen, how do employers document that? How do they calculate it? Do you have any real life examples or suggestions on how employers can make sure that they're paying and calculating the actual wage correctly?
Yeah, so we actually refer to a great worksheet or chart that the Department of Labor has shared several years ago. And you use that to determine, first of all, what the right occupation code is for this position. So, just to take a step back, as practitioners, when our clients tell us that they want to look to sponsoring somebody for an H-1B or an E3, where a labor condition application is required, the first thing we do is we ask for the job description, the job duties, and the requirements that the employer has for this position. And then we try and figure out, what is the occupation code that the Department of Labor would assign to this position. And so the Department of Labor has some great resources. One of them is the ONET site, where you can actually do a really great search based on job description to find the right SOC code. And from there, it also defines, what a job zone is. And the job zone is where the Department of Labor says that, certain occupations have minimum requirements for the position. Some positions have minimum degree requirements, some positions have no degree requirement, some have experience requirements. And so it's really critical to understand a job zone as well as the SVP for a position. And so once you've figured out and with your client, what would be the appropriate occupation code, from there you can then use this chart to see what the Department of Labor assigns as the appropriate experience and degree requirement, and what the employer also requires. And then based on that, you assign certain points, and then from there you can use that to assign what you believe to be the actual wage level, because there are four wage levels for each of these prevailing wage determinations.
Thanks for that, Naveen. And of course, we know that even in the H-1B context, employers still have the option of filing for a prevailing wage determination with the Department of Labor, like we have to do for PERMs. but that takes many months. I think right now it's probably taking 5 or 6 months. And so because, very few employers, at least up until now, have been willing to wait that long, that puts the employer in the position where they have to, in good faith, determine the prevailing wage. And so now it puts the employer and the employer's attorney in the position where they have to do the same analysis that the Department of Labor would do, which is what Naveen was discussing. And the main tool that we would normally use to look at the wages is the OEWS website, the Occupational Employment Wage Statistics website from the Bureau of Labor Statistics, which is currently down based on a current government shutdown. Normally, we look at that, and then depending on the industry, sometimes we will look at the ACUIA wages, which is for higher education. There are some situations where that wage is not available. In fact, recently I was preparing an H-1B for a physician in a very remote area, and on the OEWS website there was no wage for that whole area, and so we had to look for an alternative wage survey. And the regulations do allow for use of alternative wage surveys from other independent authoritative source that are published. And so, if there isn't a published source, and some of the common published sources are, first of all, another one that's called BLS from the Department of Labor. That's an alternative survey that's it's authoritative. It comes from the government and it can be used. And sometimes there are other published sources that can be used. Some common ones some employers subscribe to are Tower, Watson Wyatt. As long as they are authoritative sources, they're published within the last 24 months, and they have a detailed methodology identifying the median wage, they can be utilized instead of the regular OEWS wage. So I like to rely on alternative wage when OEWS is not available. I know sometimes employers feel like the OEWS wage is for some reason just grossly inaccurate. And so in those situations, they'll go to an alternative wage. But it's certainly an option if the OEWS wage is not available or does not match what the employer can pay.
Yeah, and in addition to these private wage surveys, I also wanted to note that if the position is subject to a collective bargaining agreement, then that is the first and foremost point of reference, right? And you would point to the agreement and the wage scales, and that is your best proof that this is the actual wage that the position requires. And then if there is no collective bargaining agreement and wage scale, then you go to these other surveys and sources. Also, wanted to step back, and when we're talking about actual wages, if there is a collective bargaining agreement, then that is the document that you need to refer to and the wage scale that goes with that collective bargaining agreement. And also to keep in mind that oftentimes the wage scales adjust, every year, and so you need to make sure that you're referring to the right document, and then that is the appropriate actual wage for that occupation and that employer and location. And if there isn't a collective bargaining agreement, then of course you go through the steps of using the Department of Labor's OES, or as David was talking about, the private wage surveys.
Naveen, just to clarify, would you say that the union's contracted wage is that the actual wage, or is that the prevailing wage, or does that cover both?
I say that covers both.
It would make sense because that's what everybody else is being paid, and it's also sort of a survey of what's happening in the area. Okay. So let's talk about the next topic, which is the H-1B wage versus the PERM wage determination. As we discussed earlier, when we filing a PERM, we're required to get a prevailing wage determination from the Department of Labor. And in that process, the employer completes a wage determination form that contains the title, duties, and all of the requirements and submits it to the Department of Labor. The Department of Labor will then assign it to a specific SOC code and then assign a wage based on an analysis similar to what Nabin went through earlier. And these wages are binding and they must be utilized throughout the perm process. So this definitely adds a level of rigidity as compared to the H-1B, where the employer normally determines the wage on their own. But it also creates sometimes some confusion where an employer has an H-1B in place and has a wage that they have determined to be the accurate wage. They have an SOC code that they've determined to be the right job code for the job. And sometimes it becomes a little bit tricky when the Department of Labor comes down with a wage determination that's different. Department of Labor, in the process of doing the perm, could give it a different SOC assignment, and they could even give it a different job zone and a higher wage determination. So, Naveen, what do you do in those situations where the wage for the H-1B and the perm are not in alignment?
That's a great point because when you get a wage determination for a perm process, the employer is agreeing to pay that wage once the individual receives their green card and it's admitted as a permanent resident. So it is a forward looking agreement to pay a certain wage. But oftentimes people have several years before they can actually get that green card. And so during those years, they're on an H-1B and you need to extend their H-1B status. When you have a wage determination from the Department of Labor, that is your safe harbor, and that you are paying what the Department of Labor has assigned as the appropriate SOC and wage level. Now, it's possible that while at the time the wage determination happened, the wage levels were in line with what, your employee is being paid, but every year the wages actually go up, right, in July, and it's possible that, there's gonna be a huge jump in what was wage level 2 this year versus what it's going to be next year, and maybe that wage level amount is no longer, realistic for your employee, right? So this is a discussion we often have with our employers. What do you do? The conservative answer would be to adjust somebody's salary at that wage level, but sometimes that's not realistic with what other people are being paid, which is, maybe the actual wage might be less than what the Department of Labor is assigning. And so then the employer needs to weigh the risks of, do they go back to a lower wage, maybe not wage level 3, and it maybe the wage level 2 is what is more appropriate, or maybe the SOC code, they may not have agreed with, the Department of Labor's assignment of the SOC code. So that's something that you actually need to discuss with the employer and see what the employer is comfortable with, what is realistic for their company, and what other people are being paid, and then they weigh the risk, because if there is an audit, what happens then if they don't believe that the wage determination was accurate. So something to keep in mind when looking at wage determinations and deciding what is the right wage level for an H-1B extension or an E-3 extension.
Thanks, Naveen. I know this is a tricky issue because the perm job may be exactly the same as the current H-1B position. The perm job could be a projection of what the employee will be doing in the future. And so that could be a reason for discrepancy in wages. Um, and also the person could be reassigned to different H-1B jobs and their role as an H-1B worker could be amended during the time that the perm was pending. So it's definitely a tricky issue that we need to look at. And with enforcement um, ramping up in the future, I think employers will have to even be more careful about how they handle this. Before we get into enforcement, Naveen, do you want to touch up for a moment on the new wage weighted H-1B lottery system? Because it does tie into wage and it brings some additional issues when we're discussing wage.
Yes, absolutely. I also want to note that the wage amount changes based on geography as well. So sometimes the individual decides they want to move, they want to work from home, which is in a different state, and that might lead to a different wage issue because the amount of the prevailing wage in one area of the country might be significantly different from another area. And then the lottery. So with H-1B lottery, the proposed rule is that people who are being submitted as registrants with a higher wage level, which is a wage level 4, they would have an advantage in the lottery, meaning that they may have 4 shots at that, being selected, whereas somebody at an entry level wage may, only have 1 shot, and the chance of them being selected are very reduced. As it is right now, the chance of being selected in the lottery around 30%, and so certainly for an entry level person, it may be even less once they have this wage weighted lottery system kicking in.
Thanks for that, Naveen. I know this wage weighted lottery rule was proposed in 2020, and it was later struck down because the Trump administration did not go through the proper notice and comment process. And then the Biden administration later withdrew the rule. So we'll have to see if this is really implemented. I think the administration's intent is that it will be implemented this coming March, April season. So we'll have to see what happens. If it does happen, Naveen, what do you think would be the impact on the large population of people entering the H-1B workforce, which is new graduates? What do you think is going to happen?
Yes, absolutely. I mean, certainly people who are coming right out of undergraduate, this is their first job, they are entry level positions. And so it will be very difficult for someone realistically to be selected in the lottery, whereas maybe somebody who's graduating with an MBA or an advanced degree would naturally fall into a higher level. The other point is that sometimes you have advanced degree people who are coming in at wage level 1, right? You could have a physician, this is their first job, they're highly trained individuals, but their wage level 1 is very different from a different occupation's wage level 1, right? So, something else to keep in mind there.
That wraps up this week's episode of the Immigration Brief. Please follow us on WR Immigration's LinkedIn for updates and feel free to connect with Naveen or myself directly. Thank you very much for joining us today.
Thanks, everyone.